Are you absolutely tired of not being paid for your hard work? If you're ready to learn exactly how to reclaim what's rightfully yours as a worker in Georgia, you're in the right place. Welcome to This Explainer. Today, we're breaking down the precise steps, laws, and strategies you need to recover your unpaid wages. Okay, so let's just dive right into this with a pretty major plot twist. If you're looking for the Georgia Labor Board to step in and force your boss to pay you, well, you're going to be searching for a very long time. Because actually, Georgia doesn't have a state-level wage enforcement agency with the power to investigate or collect your unpaid wages. The Georgia Department of Labor is strictly limited to things like unemployment insurance and child labor laws. They take a highly minimalist approach, which basically leaves you, the worker, to figure out how to get your own money back. Because of that lack of state enforcement, this explainer is going to guide you through the whole shebang, understanding wage claims, preparing your evidence, the federal DOL pathway, the state court pathway, timelines and expectations, and finally, resources for Georgia workers. Let's kick things off with Section 1, Understanding Wage Claims. What exactly counts as wage theft? So the absolutely crucial point here is that whether it's an unpaid federal minimum wage of $7.25 an hour, denied overtime, or unpaid bonuses, keeping your earned money is wage theft, pure and simple. Georgia follows federal wage and hour laws primarily. That means if your employer violates the Fair Labor Standards Act, or FLSA, they are straight up breaking the law in Georgia. If you've experienced literally any of these common scenarios, like, say, being forced to work off the clock, being misclassified as an independent contractor, or having management steal your tips, you likely have grounds for a claim. For example, we recently saw a case over in Atlanta where a waitress successfully recovered thousands of dollars after management illegally skimmed from the tip pool. And this applies to highly compensated professionals too. If you're fired right before your earned commissions are supposed to be paid out, you absolutely still have legal rights to that money. Moving right along to Section 2, Preparing Your Evidence. You need to document absolutely everything. You see, you literally cannot win a claim on your word alone. You need hard proof. You'll want to organize these documents neatly before you even think about filing. And here's a pro tip. If your employer doesn't have a solid record of your hours, keeping your own personal logbook, just a simple notebook tracking exactly when you clock in, clock out, and take meal breaks, can literally make or break your case. Keep copies of text messages where a manager asks you to stay late, and definitely hold on to any employment contracts or offer letters you signed. Now let's explore your first option in Section 3, the federal DOL pathway, through the U.S. Wage and Hour Division. Since Georgia won't enforce these laws for you, you can bypass the state entirely and turn to the U.S. Department of Labor's Wage and Hour Division, or WHD. Filing a federal administrative complaint with them is totally free and it's strictly confidential. In fact, investigators won't even confirm to your employer that a complaint was filed. They take on the entire burden of investigating for you. If they find a violation, they can order back wages, hit the employer with penalties, or even take them to court on your behalf. But what's really interesting here is the risk involved. Federal investigations take time, sometimes months or even years, depending on the audit. And your legal clock, it just keeps ticking while they work. Filing an administrative complaint does not pause or toll, in legal terms, the statute of limitations on your claim. So if your claim is already getting a bit old, waiting around on a federal investigation might actually mean you lose your right to sue altogether. That brings us to Section 4, the state court pathway, specifically the Georgia Magistrate Court. If you want faster action, or maybe you just don't qualify for federal help, your second option is filing a civil lawsuit in your local magistrate court, which you probably know better as small claims court. Now, in this pathway, you act as the plaintiff. That means the entire burden of proof rests squarely on your shoulders to convince the judge. You've got to draft a clear statement of claims, submit all that evidence we talked about earlier, and pay filing and share of service fees to officially notify your employer. Yes, it requires more legwork for sure, but it's often way faster. We're talking usually just 30 to 45 days from the time your employer is served until you are actually standing before a judge. This brilliantly illustrates the core differences between your two main options. The federal route is completely free, with unlimited claim limits, and those federal investigators do all the heavy lifting. On the flip side, the state route costs between $75 and $150 upfront, and you have to prove your own case. But here's a massive update. Thanks to the passage of Senate Bill 405, the claim cap in magistrate court is actually being raised to a whopping $50,000 for cases accruing on or after July 1st, 2026. That is a real game changer. Let's move into Section 5, Timelines and Expectations. Like we said, the clock is definitely ticking on your money. So, the most important thing to grasp here is that you don't have forever to claim your money. For standard federal FLSA violations, you only get 2 years to file. If you can prove your employer willfully broke the law, you get 3. But here is an incredibly cool piece of legal strategy called contractual arbitrage. If you completely miss that 2-year federal deadline, you might still recover your wages in a Georgia state court by framing it as a breach of contract instead. A verbal promise gives you 4 years to sue, and if you have a written employment contract, Georgia law gives you a massive 6-year window to take action. Okay, so what happens when you actually win? If you succeed federally, the government cuts you a check. The WHD recovers the wages and uses the Workers Owed Wages, or WOW program, to issue your electronic payment. And starting in October 2025, they're actually transitioning to an electronic-only payment model, so you'll need to register your banking info. But a quick heads up, don't just leave that money sitting there. If those recovered funds go uncollected for 3 years, the agency is legally mandated to transfer your hard-earned money straight to the U.S. Treasury. Conversely, if you win in state court, the judge will usually rule right there from the bench. But remember, winning a judgment is technically just a piece of paper. You still have to force the employer to pay up by executing post-judgment collections, which means things like property liens or bank garnishments. It sounds like a hassle, but there is a major silver lining. Under Georgia law, unpaid judgments automatically rack up a 7% annual interest rate. We've actually seen cases where workers walked away with significantly more money just because a stubborn employer dragged their feet, turning a small claim into a huge financial penalty. We've covered a lot of dense legal ground today, so let's move to Section 6, Resources for Georgia Workers and Where to Actually Find Help. Feel free to pause and save this information, because these are the exact agencies, courts, and advocacy groups you're going to need to get this process started. You can call the Federal Wage and Hour Division directly at 1-866-487-9243, or check out their local offices in Atlanta or Savannah. If you're going the state route, just search online for your specific county magistrate court clerk. And honestly, if things get complicated, never hesitate to reach out to Georgia Legal Aid or a private employment law attorney. And on that note, please keep in mind that this explainer is strictly educational and for informational purposes only. It does not constitute legal advice. For personalized guidance regarding your unique wage situation, the absolute best thing you can do is consult a qualified legal professional who really understands the exact details of your case. So I'm going to leave you with this final provocative thought. How much of your hard-earned money is just sitting right now in your employer's bank account? And which pathway will you choose today to go take it back? The statute of limitations clock is ticking on your earned wages at this very second. So please gather up your evidence, review your options, and go get what you are legally owed. If you found this breakdown helpful, please hit that like button, drop a comment, and subscribe for more explainers just like this. Thank you so much for learning with us, and we'll see you in the next one.